In my last two videos, I explained how framing the problem everyone faces at a mediation and focusing on what each side can do to prove their claims or defenses at a trial encourages the parties to move away from positional bargaining and toward a more positive negotiation effort. In this video, I'm going to provide very simple examples of how the positional approach and the can-do approach can impact negotiations. The first example involves a personal injury claim where a defendant drove into the back of a plaintiff's stationary car. At the mediation, the plaintiff's attorney opened his presentation by declaring this is a clear liability case. Now, on its face, that did not seem to be an unreasonable position to take. But note, this was a positional statement. That is, it was the plaintiff's position that the defendant was in fact liable. Having taken that stance, it would be very difficult for the plaintiff to accept there was any risk and therefore any reason to negotiate on this issue of liability. Also, whether the defense side questioned liability at this stage or not, they had little incentive to discuss it in the mediation because the plaintiff had effectively foreclosed on that discussion. Now, the ensuing negotiations in this case did not progress very well, not least because the relationship between the plaintiff's side and the defendant's carrier became somewhat strained. To be fair, both sides became positional, one regarding liability, the other regarding the scope of damages. Neither side wanted to move far from their respective positions. They were unable to reach a resolution and the case went to trial. At the trial, the defense attorney presented testimony from his client that suggested she was momentarily and not unreasonably distracted by someone else in her car. That was enough to create some degree of evidentiary risk for the plaintiff, and unfortunately for him, that risk transpired into a no liability verdict for the defendant. Now, these things happen, and even if the parties had discussed this liability evidence at the mediation, they may still have chosen to accept the risk of going to trial. And there's nothing wrong with doing that. But let's just compare that clear liability approach to one taken in a similar case that took place around the same time. At this other mediation, the plaintiff's attorney took just a few minutes to lay out, confidently and politely, all the evidence he could present to prove liability. He presented photographs that showed the defendant had a lengthy, unobstructed view of the intersection and the traffic lights as he approached them. Although the defendant had insisted at his deposition that the light ahead of him was green and he didn't expect the car in front of him to be stopped, the plaintiff's attorney provided his own client's deposition testimony in which she stated she was stopped and waiting at a red light, and he provided a statement from a third-party witness who corroborated his client's testimony. He added photographs of the two cars and also the car debris on the roadway that had been taken shortly after the collision. And he even had timings of the traffic lights, which, together with the plaintiff's testimonial evidence, further undermined the defendant's account. The plaintiff's attorney did not express any judgment about the defendant's personal presentation and credibility, but it appeared that may well have been an additional risk for the defense. With all this, and in just a few minutes, the plaintiff's attorney had laid out clearly and comprehensively what he could do to win his case on liability. The defense attorney then opened his presentation by acknowledging the evidence his counterpart had compiled and by saying it would be extremely difficult for him to win this case on liability. And that was a compliment, and judging by their smiles, both the plaintiff and her attorney appreciated it. The parties then reached a resolution based on the remaining questions of causation and damages. And those negotiations proceeded very smoothly, and it was clear the initial exchange on the liability issue had built a degree of mutual respect and goodwill that helped everyone in reaching that resolution. The mediation wrapped up with everyone shaking hands, and everyone seemed pleased with the result. Now, these are very simple but true examples. Obviously, many cases are much more complex than these, and many cases involve tragic events that are very difficult for people to overcome. But if anything, it's even more important in those cases to forgo positional presentations and to focus instead on the evidence each side can present. As with the first example above, positional presentations are really just argument, and they tend to trigger counter-argument, and neither focuses the parties on the real problem they each face, the risks of having someone else decide their case. Instead, this approach tends to steer negotiations toward positional bargaining and all the negative emotions, if not hurt, that can go along with that. The can-do example I gave, however, basically eschews all argument and instead focuses solely on the best evidence each party can present at a trial. It's effective because it focuses everyone on their respective evidentiary risks. It also objectifies and depersonalizes the mediation, making negotiations much easier for everyone. Now, so far I've explained how positive negotiations begin by framing the problem as the shared risk of having someone else resolve the party's dispute. They then continue with each side presenting what they can do, that is, what best evidence they can present to prove their claims or defenses. The next step in the process is for the parties to evaluate or appreciate the risks of the opposing party's can-do evidence. And this is where a mediator can provide considerable assistance. I'll discuss how we can work through this appreciation process in my next video. I look forward to seeing you then. Goodbye.